This is not legal advice. This is a legal education discussion for non-lawyers, by a non-lawyer. And the point is simple. When someone says, they had no permission to share my content, once that sentence is spoken, some people act like the case is over. The courthouse lights turn off. The judge slams the gavel. The copyright owner gets carried out on a golden recliner, and the accused person is dragged into the basement of bad decisions. The proper response is not, case closed. The proper response is, now analyze fair use. In fact, fair use exists because some uses of copyrighted material may be lawful without permission. That is the part people skip. They take a complicated legal analysis, stuff it into a microwave, hit the popcorn button, and out comes one burnt slogan. They didn't have permission.
There is a phrase that gets thrown around the internet, like it has magical legal powers. They did not have permission. And once that sentence is spoken, some people act like case is over. The courthouse lights turn off. The judge slams the gavel. The copyright owner gets carried out on a golden recliner, and the accused person is dragged into the basement of bad decisions. But that is not how fair use works. No permission may matter. No permission may be relevant. No permission may even be part of the copyright owner's argument. But no permission is not the end of fair use. This is not legal advice. This is a legal education discussion for non-lawyers, by a non-lawyer. And the point is simple. When someone says, they had no permission, the proper response is not, case closed. The proper response is, now analyze fair use. Fair use exists because some uses of copyrighted material may be lawful without permission. That is the part people skip. They take a complicated legal analysis, shove it into a microwave, hit the popcorn button, and out comes one burnt slogan. They didn't have permission. That may be true, but true does not always mean complete. And in law, incomplete arguments can be dangerous. Let's start with the myth that states, if a person uses copyrighted material without permission, then they automatically infringed. That sounds simple. It may even feel emotionally satisfying. A creator made the work. They own the work. They did not authorize the use. So naturally, they may think, how can someone use my work if I said no? That feeling is understandable. But the law does not stop at feelings. Copyright law gives creators important rights. Copyright is not imaginary. Copyright is not optional. Copyright does not disappear because somebody says, I was just reacting, I gave credit, or I found it on the internet. Copyright protects original works of authorship, including videos, live streams, music, writing, photographs, artwork, and other creative works. The copyright owner generally has exclusive rights, including the right to reproduce, distribute, publicly display, publicly perform, and create derivative works. So yes, permission matters. If you want to use someone else's protected work, permission is often the cleanest path. A license can avoid a fight. A written agreement can avoid confusion. Authorization can remove a lot of legal risk. But copyright rights are not unlimited. There are exceptions. There are defenses. There are limitations. And one of the most important limitations is fair use. Fair use is not some internet loophole invented by reaction channels, commentary channels, teachers, critics, or people who yell into webcams while pointing at screenshots. Fair use is part of copyright law. It is built into the system, and that means the analysis cannot simply be, did the copyright owner give permission? If that were the only question, fair use would barely need to exist. The whole point of fair use is that some uses may be allowed even when permission was not given. That does not mean every unapproved use is fair. It does not mean every commentary video is protected. It does not mean someone can take another person's entire video, add a tiny opinion on top, and declare themselves legally bulletproof. But it does mean no permission is not automatically enough. It is a starting point, not the finish line. Fair use is evaluated through 4 factors. First, The purpose and character of the use. This asks why the material was used and how it was used. Was it commentary, criticism, education, parody, news reporting? Was something new added, or was the original simply repackaged? Second, the nature of the copyrighted work. Highly creative works may receive stronger protection than more factual works. Published works may be treated differently from unpublished works. Third, the amount and substantiality used. This is not only about quantity, it is also about importance. Sometimes a small amount can be too much if it takes the heart of the work. Sometimes a larger amount may be justified if that amount is reasonably necessary for the purpose. Fourth, the effect on the potential market. This asks whether the new use substitutes for the original or harms a real or likely market for the work. If viewers no longer need to watch, buy, license, or subscribe to the original because someone else republished too much of it, that can become a serious problem. Those are the questions, not just, was permission given? Permission is a licensing question. Fair use is a legal defense question. They overlap, but they are not identical. Here is the cleanest way to say it. Fair use asks whether the unauthorized use may be legally allowed despite the copyright owner's exclusive rights. That is why no permission does not end the case. If the use is not fair, lack of permission may be a major problem. But if the use is fair, permission was not required. That is the whole point. Imagine someone reviews a movie and shows a few short clips to criticize the editing, acting, or plot. The studio may not have given permission, but that does not automatically mean the review is unlawful. The question is whether the clips were used for criticism or commentary, whether the amount used was reasonable, and whether the review substitutes for watching the movie. Imagine someone quotes from a public statement to analyze what was said. The person quoted may not like it. They may not have authorized it. They may even demand that it be removed. But if the quote is being used for commentary, criticism, or reporting, the analysis does not stop at permission. Imagine someone uses a screenshot from a live stream to discuss a public controversy. Again, the question is not simply, did the live stream owner approve? The question is, what was used? Why was it used? How much was used? Was commentary added? Did it replace the original? Did it harm the market? It is fair use analysis, not slogan analysis. Internet arguments love slogan analysis because slogans are faster. They are also usually worse. This is where people get tangled. Permission and fair use are different legal lanes. Permission asks, did the owner authorize this use? Fair use asks, may this unauthorized use be allowed under the fair use doctrine? Those are different questions. A person can have permission and not need fair use. A person can lack permission and still argue fair use. A person can claim fair use and lose. Also, a person can have no meaningful fair use argument at all if they copied too much, added too little, and harmed the market for the original. So, this is not a defense of stealing content. It is not a defense of lazy copying. It is not a defense of taking someone's entire live stream, putting a smirk in the corner, and calling it commentary. There is a difference between using copyrighted material to make a point and using copyrighted material because it is easier than making your own content. Courts care about that difference. Platforms may care about that difference. Creators should care about that difference. But the answer is not to pretend that lack of permission ends the analysis. It does not. Fair use frequently comes up in commentary and criticism because commentary and criticism often require showing or quoting the thing being discussed. You cannot meaningfully critique a statement without identifying the statement. You cannot effectively analyze a video clip without sometimes showing the clip. You cannot explain why a public claim is misleading without quoting enough of the claim for viewers to understand the issue. This is why fair use matters. It prevents copyright from being used as a muzzle. But again, purpose does not automatically win the case. A person cannot just say, "This is educational," and then upload an entire documentary. A person cannot just say, "This is commentary," and then play 40 minutes of someone else's live stream with 3 minutes of reaction sprinkled over it like legal parsley. The use still has to be examined. The commentary has to matter. The amount used has to make sense. The market effect has to be considered. Fair use is flexible, but it is not fake. Now let's talk about the messy online materials. Screenshots, clips, transcripts, live streams, community posts, member-only content, chat logs. A screenshot may be fair use when it is used to identify, criticize, explain, or document something. But a screenshot is not automatically fair just because it is a screenshot. A short clip may be fair use if it is necessary for commentary. But a short clip is not automatically fair just because it is short. A transcript excerpt may be fair use if used for analysis. But copying an entire transcript and republishing it may create a stronger copyright problem. A live stream segment may be fair use if it is used to comment on what happened. But replaying the best parts of someone else's stream, so viewers do not need to watch the original, creates risk. Member-only content deserves special attention. Some people act like fair use can never apply to paywalled or member-only content. That is too broad. Other people act like member-only status does not matter at all. That is also too broad. Restricted access may affect the analysis, especially the market effect factor. If someone takes paid content and republishes enough of it that viewers no longer need to pay for access, the fair use argument gets weaker. But even then, the analysis does not end at, "It was members only." The questions remain. What was used? How much? For what purpose? Was it criticism, commentary, reporting, or evidence of something being discussed? Did it replace the original paid content? Fair use is about the use, not just the source. This subject also connects to cease-and-desist letters. A cease-and-desist letter may say, "You used my copyrighted work without permission." That may be the copyright owner's position, but a cease-and-desist letter is not a court ruling. It is not a verdict. It is not a finding of infringement. It is a demand. It is notice. It is a warning. Sometimes it is serious. Sometimes it is exaggerated. Sometimes it is carefully written. Sometimes it is a legal pinata filled with assumptions, accusations, and emotional confetti. The fact that a letter says, "No permission was given," does not resolve fair use. It tells you what the sender claims. It does not tell you whether the claim would win. Now, we also need to be honest on the other side. Just as no permission does not automatically defeat fair use, saying fair use does not automatically create fair use. This is the other myth. Someone gets accused of infringement and immediately says, "It's fair use." Okay, maybe. But why? Which factor helps you? What did you add? How much did you take? Did you take only what was necessary? Did viewers still need the original after watching your version? Did your use compete with the original? Fair use is not a sticker you slap on a video after the fact. It is not a costume. It is not a shield made of cardboard with Section 107 written in crayon. It is a legal analysis. Sometimes the person claiming fair use has a strong argument. Sometimes they do not. The problem is that online audiences often pick a side before doing the analysis. One side chants, "No permission." The other side chants, "Fair use." And somewhere in the middle, the actual law is sitting at the table, wondering if anyone plans to read it. Here is the better framework. First, identify the copyrighted material. Was it a clip, screenshot, song, transcript, graphic, whole video? Second, identify the use. Was it copied, displayed, distributed, transformed, commented on, criticized, or republished? Third, ask whether there was permission. If yes, the issue may be easier. If no, keep going. Fourth, analyze fair use, purpose and character, nature of the work, amount and substantiality, market effect. Fifth, be honest about the strength of the argument. Do not pretend every criticism is fair use. Do not pretend every unapproved use is infringement. Do not pretend a cease-and-desist letter is a judicial opinion. Do not pretend a YouTube claim is a final legal determination. Definitely do not pretend that yelling "no permission" into the internet makes the 4 factors disappear. That is not legal analysis. That is a fog machine with a filing cabinet. So here is the takeaway. No permission is a real point. It should not be ignored. If someone used copyrighted material and did not have permission, they may need a defense, and fair use may be that defense. But the defense has to be supported by the facts. On the other hand, a copyright owner cannot honestly end the analysis by saying, "I did not give permission." That skips the central question. Was this unauthorized use legally allowed anyway? That is why fair use exists. So both extremes are wrong. No permission means automatic infringement is wrong. I said fair use, so I automatically win is also wrong. The accurate answer is this: no permission may matter, but fair use determines whether the unauthorized use may be legally allowed despite the lack of permission. So the next time someone waves around the phrase "no permission" like it is a legal lightsaber, remember this: no permission may start the argument. It does not end the analysis. Fair use exists because some uses are allowed without permission, and if that makes the comment section uncomfortable, then congratulations. Fair use exists because some uses are allowed without permission, and if that makes the comment section uncomfortable, then congratulations. We have finally reached the part where the law becomes more important than volume of the opposing voice.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.